difficult to know from what we've been told.
Okay.
The bodies represented are the same. Ravec seems to have people at a more senior level.
Yes, up to a point that the same bodies are represented, but it's the additional people that are on the RMB, which Mr. Hipgrave identifies,
Right.
which I will come back to.
All right.
And obviously the court will have the point that representation of the same bodies doesn't imply that those individuals have the same expertise, even though they are part of the same bodies. The third strand is the nature of the information and analysis that Ravec gets when making decisions. And here we know that the RMB considers threat. So that's Mr. Hipgrave's first statement, paragraph 61. And we also know that this is different from what is contained in the threat assessments, because what the RMB is doing is getting those documents and analysing them. And we get that from Mr. Hipgrave's first statement, paragraph 57, where he says that the RMB gets the threat assessment. It's not their job to, as he puts it, and I'm quoting, question or second guess the assessment level, end quotation. Instead, what he does, or it's what the RMB does, is analyse the information to, and I quote again, reach an overall view of the threat potential, with that being, he says, a judgment and evaluative exercise rather than a mechanistic one. Now, the reason I mention all of this, and those quotes were from paragraph 61, is we'll come back to the difference in the closed session in detail between what the RMB does and what the so-called bespoke process involves. But what you can see from Mr. Hipgrave's first statement, paragraphs 57 and 61, is it's not just the information that matters, it's who is analysing it. Because under the RMB process, the RMB is analysing it. We know now, under the bespoke process, that it's Ravec that's analysing it. And that's a point that I will return to. Mr. Hipgrave also says, importantly, at paragraph 20 of his second statement, which is supplementary page 163, he says, and I quote, that the RMB analysis is qualitatively different from a threat assessment. So it's not enough just to have the threat assessment, because first of all you have the RMB's analysis, but then he's going on to say that that is itself qualitatively different. And in paragraph 31 of Mottram 2, which is supplementary page 152, he notes that the RMB process, and I quote, is focused on the wider issue of risk, not just threat. So this is all in the context of what is it that Ravec gets when it's going through the normal RMB process. So we know that RMB considers threat, and we know what it's bringing to the table when it's considering threat. It's the analysis, and it's the qualitative difference in that analysis. The second thing the RMB considers is impact. And that's Mr. Hipgrave's first statement, paragraph 62, supplementary, page 94. And there are a range of factors that go into impact, and I will come back to that. And then there is another factor, which I will not describe, but is set out in Mr. Hipgrave's first statement at paragraph 64. Just invite the court to have a quick look at that, given that I'm restricted in what I can say.
Which bundle reference?
Supplementary 94. So I just want you, for your notes, to be able to jot that down, and I will come back to it.
What paragraph is it?
It's paragraph 64. So that's another factor that is considered. Now, he tells us, Mr. Hipgrave, that, and again I'm quoting, all of these matters are put together by the RMB to create a consolidated risk profile for the individual comprising threat, impact of a successful attack and risk. This will also include a recommendation for protective security mitigations, end quote. That's paragraph 65. It's supplementary, page 95. And he then says that the work of the RMB is considered by Ravec. That's paragraph 69, supplementary 95. So that is what Ravec gets when it gets an RMB assessment. It has an assessment that is looking at the things I've just described. The fourth contextual strand is what we know about the RMB assessments that have been done for others and when they've been done. And this is based on the description, which I emphasize is for the purposes of this litigation, of the three broad categories that are described in the evidence. And for the court's reference, that's Mr. Hipgrave's first statement, paras 29 and 31, supplementary, page 86. And giving a broad summary, what we know is that most of those provided with protective security are in the role-based category. That's Hipgrave 1, para 32, supplementary 87. And he says that in general, it's expected that the RMB will consider each principle within Ravec's cohort annually. That's Hipgrave 1, para 66. And that, in general, I should say, appears to be a reference to the annual consideration rather than to the RMB being done in the first place, because at the end of that paragraph, he makes the point that there may be decisions that need to be taken out of the usual RMB process, and he notes that, and I quote, urgent assistance may be required from the RMB Secretariat and such members as are available to assist on an ad hoc basis, end quote. That's Hipgrave 1, para 66. And I already showed you Annex A to make the point that even with those ad hoc, out of the ordinary cycle process meetings, the RMB goes first. He describes the assessment as one important consideration for all decisions on the protective security to be provided to principals. That's Hipgrave 1, para 54, supplementary, page 91. Now, he does say in one passage that the judge relied on that the RMB may be invited by Ravec to consider risk assessing any individual for their potential inclusion within the cohort. That's Hipgrave 1, para 59, supplementary 93. Now, the judge placed emphasis on the use of the word may rather than must. That's in the judgment at para 162. And in our submission, he was wrong to do so because, as the court knows, my submission from earlier today, there's nothing in Ravec's terms of reference that suggests that the RMB is anything other than mandatory for anyone within Ravec's remit. And secondly, there's nothing in the evidence of Ravec's practice to suggest that the RMB was not carried out for those who had previously had protective security. And that is why we say that the appellant has been singled out in this unjustified and, we would say, inferior way. And I'm going to return in the closed session to give you some more submissions about that fourth strand. That is to say, how it's been applied in practice, the individuals to whom it has been applied, and so on. And if I may, I'm going to give placeholders, in case you're taking a note, to say that that's private point 1, so that when I come back to it in closed, hopefully you will be able to slot the submission in to the note that you're making. My lords, the errors in the judgment. There are 3 errors that the judge made. The first is that he said that the 2017 terms of reference did not require Ravec to do an RMB before making decisions as to whether or not someone gets protective security and if so, what? So he treated it as something optional, and we say that's where he got off on completely the wrong foot. And even though he went on...
Which paragraph is your criticism relating to?
I'm going to go through several, but 162 is the one that I've just described.
Thank you.
Even though he went on to do the good reason analysis, so he considered the possibility that the 2017 terms of reference did require an RMB, we say that his starting point of the discretionary voluntary nature of it infected that analysis. Now, at the judgment 162, and if I can ask you to have a look at that, it's in the core at 135. The judge makes 3 points in this paragraph. First of all, he says that the terms of reference cannot be treated as hard-edged policy documents. That's about 7 lines down. 162. If that is intended to mean that the terms of reference do not mean what a reasonable and literate person would understand them to mean, then we submit that that's wrong. And that does appear to be what the judge means, because he then goes on to say the words, that the words cannot be taken at face value. And you see that just a couple of lines down. His second point is, he says it's immediately apparent that the words cannot be taken at face value because of the present point, which I've already addressed, so I'm not going to go back over that. I've explained why that is also wrong, that our construction doesn't lead to that conclusion. And then the third point he makes is to say that paragraph 20, like the rest of the document, must therefore be read on the basis that it is being used by Ravec members, in particular at this time the chair, by reference to a number of value judgments. And he says that it is Mr. Hipgrave's evidence that the RMB may not must be invited to do the RMB. Now, I've already addressed that part of Mr. Hipgrave's evidence, so can I just say something about this wider point that the judge is making in this paragraph? This wider point crops up at a number of points in the judgment. So, for example, could I ask you to look at 158, which is on page 134? And you can see there that he says, about 4 lines down from the top, the subject matter at issue and the expertise and constitutional responsibilities of the relevant decision makers will be relevant to the court's task of construing the terms of the policy and the nature and scope of the practice. Now, as I hope is not a surprise to my lords, if that is intended to mean that this is relevant context which informs the court's approach to interpretation, then that's fine. But he seems to want to go further with this point. He seems to say that the court should interpret the policy in the way in which the decision maker has chosen to apply it. And if that is what he means, then that is wrong, and that is the second error in his judgment. So the first is the one I showed you at 162 earlier in terms of interpretation. The second error is this deference approach that he gives to the terms of reference as a whole. And as I say, it crops up in a number of places. Can I just show you another place, which is paragraph 175, and that is on page 141. So again, he goes back to this deference or expertise point. He says that the defendant's witnesses can be taken to have a thorough understanding of the Ravec terms of reference, and you see that 4 lines from the top. Now, that appears to be an application of the Hopkins presumption, because as you can see from paragraph 176, he rejected my submission that one cannot extrapolate from Lord Carnwath's judgment any general proposition. So 175 and 176 appear to be yet more of the expertise point that we've seen in 158 and 162. And you already have my submissions on why Hopkins is not authority for the general presumption that the judge appears to be applying, and therefore these paragraphs show an error of law. Then could we have a look at paragraph 178? This is the third and final interpretation error, which we say is wrong. Here the judge appears to have concluded that the 2017 terms of reference...
Sorry, I lost the paragraph. 159?
178 now, my lord.
178,
It's 178. It's on page 142.
Yes.
So this is the third error. And what he appears to have concluded is that the 2017 terms of reference did not apply to Ravec's decision-making in relation to the appellant in 2020, and he doesn't therefore go on to consider the question about the scope of the terms of reference, and in particular who it applies to, and the fact that that is, in our submission, something that is determined by the content of the TOR. So that's the remit point. And we say that his analysis here has three mistakes in it. First of all, he ignored the fact that on the evidence before him, he knew that the appellant's interpretation is consistent not just with the language of the terms of reference, but also with Ravec's practice. And I've put it in that way because that's my private point one again, which is who else has had the RMB? The judge had heard our submissions on that, and he made an error because he didn't take that into account. He also ignores the evidence of Mr. Hipgrave in Hipgrave 1, para 25. I referred to that earlier as well. That is also a paragraph which I will show you later, and it deals with the remit question.
Page?
Supplementary 85.
Thank you.
And third, he ignores the evidence of Sir Richard, which I've already covered with you, and that's Mottram 1, paragraph 14, where Sir Richard says they weren't applied to the appellant because of his change of status. The judge then, on the interpretation part of the judgment, he looks at the position of others at paragraphs 179 to 190. Now, some of that analysis is about good reason, but some of it bears on interpretation. And so that's all going to be part of my private point one. So could I now turn to grounds 1B and 1C? The key parts of the judgment that relate to this, again, if it's helpful for you to have them at the outset, are 155, 158, and 159. That's on the law.
Did you say 159?
Yes, my lord. And then on the facts and the application of the standard to the facts, it's 165 to 168, 170 to 173, 175, 180, 186, and 190. I have 4 overarching submissions on good reason, and they fall to be considered against the backdrop of the points on interpretation that I've already made. The first overarching submission is to identify the correct question for the court. And that question applies to both the judge and this court, provided, of course, that this court agrees with us that the judge was wrong. So if, having exercised that decision in our favour, you then wish to consider the submissions, you will also apply, in my submission, the same test as the one that the judge should have applied in the first place. And applying Munjaz and Tower Hamlets, we say the question is this: whether on the basis of the evidence adduced, the court considers that Ravec has shown that it has a cogent or compelling reason high, and there are 3 reasons for that. The first is the importance of the safety and security of the appellant. That justifies the need for particularly cogent reasoning. I hope the court has had the opportunity to read the appellant's witness statements. He describes in them the position that he has benefited from in terms of protective security over his life. And that is an important backdrop for this point that I'm making now. And so if I could paraphrase paragraph 21 of what Lord Bingham said in Munjaz, we invite the court to scrutinise the reasons given by Ravec with the intensity which the importance and sensitivity of the subject matter, the safety and security of the appellant justifies. Second, we say the clear, unqualified requirement that Ravec's protective security decisions must be based on the RMB justifies the need for particularly cogent and particularly compelling reasons. And I've already explained that this is not based on some literal interpretation of the terms of reference. The court has seen the recommendations of the Tesh Review quoted in the EC and the rationale for why the RMB is so important. And we also have the practical application of the terms of reference. We know from the evidence how widely and consistently the requirement to do an RMB is honoured by Ravec. And there is no other person in all the evidence before the court that has been treated similarly to the appellant in being denied an RMB. And we say that that is the second reason for that especially high threshold. Third, the extent of Ravec's departure from the terms of reference justifies the need for particularly cogent reasoning. And as I said at the outset, as my first introductory point, it's common ground that Ravec has failed to do the RMB in advance of taking the February 2020 decision. And we say that stark and wholesale departure from the requirement of the terms of reference is something that needs to be taken into account. So having made those 2 overarching submissions, can I just pause to look at the judgment insofar as it relates to what I've just said? I've already addressed substantively the point in the judgment at para 155. This is page 132. This is the Munjaz point. And the judge says there, he quotes parts of Munjaz, and after referring to paragraph 69 and quoting from Lord Hope, he says, I would emphatically reject any suggestion. He says, as will be apparent from what I say at paras 159, the background and subject matter of Munjaz in the present case could hardly be more different. And he essentially then says that what Lord Hope said cannot simply be carried over to the circumstances of the present case. That's at the top of page 133. We submit that as a matter of principle, those comments can be carried over to this case because there's no analytical difference that is relevant between the background and subject matter of Munjaz and this case. Can I just explain what I mean by that? The court will recall that I showed you the 3 points that Mr. Munjaz relied on that were described in paragraph 20 of Lord Bingham's speech. There was consultation on the code in Munjaz, and we say that we have the Tesh Review and the College of Policing reports in this case. So just as that consultation heightened the threshold, so the Tesh Review and the College of Policing reports heighten the threshold here. This is not advisory. This is not discretionary. This has been developed after taking those reports into account. There was the high importance of protecting detained mental health patients in Munjaz, and as I've just explained, there is the importance of the safety and security of the appellant in this case. So far we have 2 out of 3 in terms of the qualitative points. True it is, of course, that unlike Munjaz, the 2017 Terms of Reference was not issued by the Home Secretary. But that is not a material factor when it is remembered that there was no express obligation on hospitals to follow the code. So there was certainly a statutory backdrop in Munjaz, but that backdrop does not justify a different analysis on the facts of this case. And then he carries on, staying in the judgment at para 155, he carries on and distinguishes Tower Hamlets on the basis that he says it was also a case about statutory guidance, and for the same reasons we say that's not a material distinction when considering what is required by the good reason test. The court will recall that I said that the analytical search is for factors that show that the policy in question is more than merely advisory. Now, those factors could include things that relate to the statutory provenance of the policy, but they don't have to. And you don't have to have that statutory provenance in order to get into Munjaz and Tower Hamlets. So we say that the judge was wrong at the end of that paragraph to say these cases shed no relevant light on the matters with which I'm concerned. Of course, they don't shed any factually relevant light, but they identify the correct legal test, and that legal test, we say, is to be applied whenever on analysis the policy in question is intended to be very much more than advice which the decision maker might choose to follow or not to follow. That's a paraphrasing of paragraph 20 of Munjaz. So, my lords, we say that the judge erred in the application of the Nadaraja good reason test because he failed to hold Ravec to the Munjaz standard of cogent or compelling reasons. That is the right test, and that is the one he should have applied. He applied a lower standard. Staying in the judgment at paragraph 158, which is on page 134, he rightly noted at the start of that paragraph that the Nadaraja principle is not a rigid one, and he also rightly noted at the end of that paragraph that the expression good reason is a protean one in nature. But that is because the answer to the question, was there a good reason, will always be fact sensitive. That's where we get the versatility. But we don't have a difference in terms of the applicable framework for that question in principle. That is there a cogent or compelling reason? And then moving through the judgment at 159, we see that he notes that the decision-making in this case doesn't have a statutory context. He says it's an aspect of the raw prerogative. Again, that's the same as the point I've already addressed, which is the source of the decision-making power doesn't change the need for the cogent or compelling reason. And the court may have noted when I was going through Raisi that that was a prerogative power case. So that was the ministerial statement about the ex gratia compensation scheme. And he says at the end of para 159 that the assertion that Sir Richard should have thought to initiate an RMB assessment is close to being a Tameside challenge, and such challenges are founded on irrationality. That is a bad point in our submission because our assertion regarding the need for the RMB is rooted in Ravec's own policy, so it's not a Tameside challenge. And then if we see paragraph 176, that is again the expertise point, which I've already addressed. That's page 141. So those are the first and second overarching issues on good reason and why we say that the judge erred in relation to them. My third overarching submission is that the judge's factual findings regarding Sir Richard's reason for not doing an RMB do not disclose a cogent or compelling reason. And I should say, for the avoidance of doubt and dealing with the respondent's notice point, that in our submission, the reason provided would meet the Wednesbury standard. Would not meet the Wednesbury standard. Could I start by looking at the judge's factual findings? I gave you the references earlier, so if I could just go through some of those. So starting at 166, please.
Starting at which paragraph?
Paragraph 166, my lord, page 136. And you'll recall that I said that there were two groups of factual findings. The one that relate to the judge's factual findings as to Ravec's reason for not doing the RMB, and the second to his own findings. So if I can just give you the overview, 166 and 167 are describing the contemporaneous documents. So those are the three emails, 24th, 6th and 7th of February.
Yes.
168 is summarising the witness evidence in Mottram 1, especially para 75. 170 summarises the witness evidence in Mottram 2, paras 36 and 37. 172 summarises the witness evidence in Hipgrave 2. Now, Mr. Hipgrave doesn't address Ravec's reason for not doing the RMB in February 2020, because obviously he wasn't the decision maker or involved with it, but his evidence is purporting to support and justify that decision. So that's why his evidence is referred to there. And there is a similar point which applies to 173, which is the witness evidence of the current chair.
I'm not quite grasping what point you're trying to make by going through these paragraphs which just refer to the evidence.
Because I'm about to make submissions on why he erred in what he found in them, and I want you to know what I'm basing my submission on. So it's these factual findings. It's the description of the emails, it's the bits of Mottram 1, Hipgrave 2, and Mottram 2, I should have said, and the current chair's evidence. And it's those specific passages.
Yes.
In relation to the others, the challenges that he makes himself the findings he makes himself, those are, as I said to you, 165, and the factual finding that he makes there is he says an RMB assessment had at the time certain significant limitations, which is referring to February 2020. And the court will see that on page 136. Single sentence is a factual finding.
Single sentence where?
Paragraph 165,
Yeah.
page 136,
Yeah.
second sentence.
The
So-
good reason finding.
I'm so sorry, my lord.
It's a good reason finding.
That's a factual, yes, it's a good reason finding. It's a factual finding that he has made that is not in the evidence. It's an inference that he has derived from paragraph 9 of the evaluation criteria paper. So you can see that in paragraph 164 he sets it out, and then he says in 165 it doesn't assist the appellant. He makes that statement, and then he says it supports the defendant's case. And my submission is that there's no basis for that factual finding, and it's wrong. And there are 5 reasons why that factual finding is wrong. And the reason I want to make submissions on it is obviously, as part of the good reason analysis, this court needs to consider whether or not his factual finding is right, that in 2020 the RMB assessment had significant limitations. And we say that, first of all, the basis for this, which is paragraph 9 of the EC, doesn't support the inference that he's derived from it. So can I just remind you of what paragraph 9 of the EC said? It's supplementary tab 12, supplementary tab 12, page 174. So we looked at this earlier, and the bit that the judge relies on is the bit after the redaction beginning the RMB review. So that's the passage that he's quoted in his para 164. And it's essentially a recommendation that there is a more holistic and in-depth look. That's what's being said. The fact that the RMB assessment could be made more holistic and more detailed does not, in our submission, mean that it can be inferred that at that time it was, as the judge found, significantly limited. Nor does the potential for improvement change or diminish the stated role of the RMB, namely, as we see at the start of that paragraph, that it was a crucial part of Ravec's considerations. Third, there's no evidence that supports the judge's conclusion. So Sir Richard's evidence doesn't support that conclusion. And fourth, the contemporary evidence is that an up-to-date RMB would have been of assistance. When considering the arrangements for the June visit, the police asked for the most recent RMB assessment. And you have that in Hipgrave 1, paras 131 to 132. So the police plainly considered that the RMB assessment was relevant for the purposes of the June 2021 visit. Finally, the point in paragraph 9 that's being made is different to the one that is being made by Sir Richard and which the judge describes in para 165. The EC is saying that the assessment could be made more detailed. Sir Richard's evidence is not that the RMB wasn't detailed enough. That's not what he has said. He has said that the RMB wouldn't have the information they needed in the appellant's case to meaningfully do one part of the assessment. That's his evidence. And I'm going to develop that point in the closed session, but the headline point is that the judge appears to have misunderstood Sir Richard's evidence on this. That factual finding in 165 is repeated, as I said, in 171. It's put in a slightly different way. But then, if I could ask you, let me just show you that, please. It's 138. And he says, far from assisting the claimant for the reasons I have given, and then over the page, the evaluation criteria support the fact that at the time an RMB assessment of the claimant would have been likely to be of less practical utility than the visit than certain arrangements. So that is a very similar point to the one he's making in 165. And then, if I can just show you quickly some bits of 172, which I'm going to come back to. He refers to the fact in 172, he says, he refers to Mr. Hipgrave's evidence, and I think it's It's just over halfway through that paragraph. This means that a more focused, much more focused. Do you have that, my lord?
Yes.
That bit there, much more focused consideration can be given, informed in particular by the views of the MPS. So that, and then you see the latter part of that paragraph, which I'm not going to read out, in terms of what Mr. Hipgrave says about the role of the RMB. And similarly, in para 173, you see the evidence of the current chair. And if you go over the page, you will see that there is a passage which is redacted, which explains his view. The quotation begins, allows Ravec to reach.
Yes.
So the judge took into account all that evidence, and I'm going to address this in the closed session in detail by reference to what the RMB does, what is done in the bespoke process, what the difference is. I'm going to try and answer my Lord Master of the Rolls' question to me about how this figures basically in relation to the appellant. But I wanted to show you now that those are the passages I will be challenging. And then in 190, the judge says, and this is page 146, he refers to Sir Richard's view that it was not possible for Ravec at that point to see how matters regarding the claimant would develop. I'm reading from about halfway down in that paragraph, and then there's the sentence, the position would not have been materially affected if an RMB assessment had been commissioned at the time. That's another factual finding that I say is wrong, and I'm going to deal with that also when I deal with the closed evidence. I should just say it's not entirely clear what the judge bases that assertion on. It appears to be based on the passages I've shown you. So the bits from Mottram 1, Mottram 2, Hipgrave 2, and the current chair's evidence. But in any event, I'm going to come back and address on the evidence why those factual findings don't, in our submission, warrant being upheld. The rationale found by the judge to explain the lack of the RMB does not, in our submission, disclose a good reason for 5 principal reasons. Now, I can't articulate all 5 of them now. I'm going to address them in private point 2, but can I just give you the essence of what the submission is going to be? The RMB is a fundamentally different exercise from the so-called bespoke process. It's done by people with specific expertise, and it focuses on distinct factors. The fact that the appellant is living abroad and comes back here from time to time does not in any sense dilute the relevance of those distinct factors when his security is being considered. And the so-called bespoke process and the expertise being applied to that process are, in our submission, not only fundamentally different, but fundamentally inferior for the appellant than for any other individual within the Ravec cohort. And I will develop all of that in the closed session and submit that in light of that analysis, there's no good reason, let alone one that is cogent or compelling. The 4th overarching submission I have on good reason is that little weight can be attached to the witness evidence, because first of all, the explanation in the witness evidence is not to be found in the contemporaneous documents, And second, the witness evidence has been given almost 3 years after the decision in question.
Same point, is it?
My Lord, no, in the sense that, well, perhaps I can show you the documents, because the documents are so thin that it's very difficult to understand what they mean, let alone distill
The contemporary documents.
the contemporary documents. So that's one point. We don't see it. And when one has to recollect that the terms of reference, especially back in 2017 when the chair was making these decisions, one would expect the chair to be comforted by the framework in the terms of reference. They're there to protect him as much as anybody else. That wasn't followed. That process wasn't followed. As I've said, it's common ground. And so you might expect that the chair in that position would be taking great care to document what he was doing in this. In his own evidence, he describes it as an unusual and high-profile case. But we don't see that. So that is the contemporaneous documents. But the second point is the passage of time when it is about something that was in someone's mind, an opinion or a belief. And my lords will be familiar with the difficulties of any witness recalling what was in their mind 3 years after the event in question, especially when the underlying documents are so thin. So this really does just go to weight, though, as I've said. The judge gave the witness evidence significant weight. That was how he described it. In my submission, it has little weight because of those two factors. Can I show you the first of the emails in question? This is tab 20 of supplementary bundle, and it starts, as with email change, you have to work backwards. It starts on page 207.
In the supplementary, right?
Yes, and I'm so sorry. Could I just ask you to look at 206 because you can see the sender. So you can see it's from Sir Richard at the bottom of 206. It's 24th of February 2020, sent at 1910. And you see there the names of the recipients.
Yes.
And can I ask you just to have a look at this email? The two sentences after the bullet points.
Oh, I must be in the wrong one. Yes.
So you see the bullet points, my lord.
I've got it, yeah.
And I think it's two sentences, but
So
in any
this
event,
is
it's
the
a line and a
24th
half.
of February email.
24th of February.
Yes, thank you.
If I could just ask you to read that little bit that is outlined in the green.
Mm-hmm. Yes.
And it's the 7th, 8th and 9th lines. That are the focus there. So my lords see that.
As we discussed.
Yes. And then the section which is unredacted, if we follow this line of argument. So the argument is there above. And then the consequence of the line of argument, as he puts it, is there would be no RMB. So that is the sum total of the contemporaneous explanation from the chair. Now, what we have in response to this email is one of the recipients querying what it means. So it's so unclear that one of the recipients doesn't even understand what its meaning is. Can I show you that email? That's on page 204. And you see halfway up that page who it's from. That person was one of the recipients. It's sent 2 days later on the 26th of February. And you can see there that he says...
Yes, you're referring to point 4, are you?
No, my lord, I'm referring to point 1. He says, following your email on Monday, am I correct in understanding this means that there will not be, and then you can see what's set out there. So the person getting it didn't really understand, and you can see the last sentence, I suspect we will be pushed for this clarity. So, big red flag for Sir Richard. Haven't explained it particularly clearly, and we do need it to be clear.
I mean, big red flag might be overstating that paragraph, mightn't it? He's understood it, actually, because he repeats it.
Well, but it's somebody else, my lord. It's never a good thing if somebody has to say back to you to check whether or not they've understood what you've meant.
Okay.
And also, there is that point about being pushed for clarity. So there was an opportunity for Sir Richard to come back and explain, and we see his response on page 203. And you can see it's 2/3 of the way down. You see that's the response from him. It's the 27th of February. It's going back to that same person. And his response is, your understanding is correct.
Yes, but so what's wrong with that?
Well, if you now go back and look at what was said in the clarification, so if you go back to para 1 on page 204, it doesn't say anything in terms of the methodology not being meaningful, which is the explanation we have in the witness evidence. What it's saying, if I can paraphrase, is we're not doing the RMB because we're doing something else. So what you see in the witness evidence now, in my submission, is nowhere to be found. It's not in Sir Richard's first email. It's not in the clarification.
So just be a bit clearer, can you, about that submission? I don't fully understand it. Just say it again. What do you say is in the submission now that is not prefaced in the documents we're looking at?
An explanation.
An explanation for what?
Not doing the RMB.
Right, so you say there's no explanation for not doing the RMB in this email exchange.
Well, it depends on what my lords regard as an explanation. In my submission, it's not an explanation. What it says is, we're not doing X because we're doing Y. It doesn't say, we're not doing X, we're doing Y because. And so in my submission, to say that you're doing something other than you should be isn't explaining why you're doing it. What you get now in the witness evidence is the why. You get we're not doing the RMB, we are doing bespoke because. There's no because in these 3 emails.
I mean, can you say why they say in the witness statements? I can't remember if it's confidential.
In a nutshell, it's that the RMB's methodology no longer suited the appellant's circumstances.
Right.
think that's as much as I can say. But I will come back to it, my lord. I'm not going to leave you with that rather short explanation.
I see it a bit more simply than all this. It's this afternoon you made, if I may say so, some rather closely reasoned submissions by reference to bits of evidence here and there and the judge's reasoning. But these emails seem to me to sort of say what they mean and mean what they say. They say in very simple terms, and things don't have to be complicated just because they're important, right? I mean, I hope you would accept that at least. You don't have to have 500 pages to say a very simple thing, like, for example, the safety and security of the claimant is very important. That only takes a few words. And these emails, just reading them fairly, do seem to say, and I'm reading out something that I think is not redacted, there will not be an RMB on the grounds that this is no longer required given alternative governance arrangements being established for the claimant. So there's another solution. That's what's being said. Now, you say that's wrong based upon an interpretation of the TOR, terms of reference, that there has to be an RMB. Now, what if there doesn't have to be an RMB? Why is that reasoning so flawed?
Well, can I, this is why we need to go back to everything I've said. I'm not going to repeat myself, but my lords have my point about clarity, logic, and convincing. When you're looking at the material, I'm asking you to look to see whether there is a clear, logical, and convincing explanation. I agree with my lord that it does not need to be 500 pages long. The brevity of the emails is not the point. It could have been succinctly stated. But the brevity is an indication of the thought that was perhaps being given to it. But what you don't see...
I mean, you're not suggesting this wasn't taken unbelievably seriously, I'm sure.
I'm not suggesting that at all. I'm suggesting that the reasoning that we see is not clear, it's not logical, it's not convincing. And the reasoning we see in the witness statement is similarly, as I will develop in the close.
This is why I'm picking you up, Ms. Fatima. You state that as if it is obviously the case. But
which bits, my lord?
You state that the reason given that I read to you a moment ago is not cogent, convincing, and whatever the other word is you use, as if it's a fact. But what I'm trying to get you to explain is why you say, when they are considering the situation, I put it to you this morning as well, of a member of the royal family who's stepping back from his public duties and going to live abroad, and will come back on ad hoc occasions yet to be specified, and I'm conscious that some were specified in an email from the private secretary, but leaving those aside, why it is self-evident, or why we should take it as self-evident and hold that it was the judge was self-evidently wrong about this, that an RMB wouldn't have helped in the decision that a bespoke arrangement is a better arrangement for this person, for the protection of this person.
Yes, and my lord, I am in some difficulty, as I hope the court will appreciate, because I cannot give you my full submissions.
Well, no, but I mean, is your full submission, but I think we do get the point. We understand what private point 1 is and private point 2. I mean, is your submission the comparison with others? Or is the submission, what is it that makes it self-evident that this was not cogent?
I entirely see where the court is coming from. You will recall that when I gave you my contextual points, the second, the third and fourth was the information that Ravec gets when it does the RMB and how it's then approached that for others. There are two parts to the answer to my Lord's question.
Right.
When I will hopefully show you what the RMB does in more detail, when I can make more candid submissions showing you, it will be my submission that there are things that the RMB does, very significant things, views that it gives that are now being done by others. Now, one has to anticipate and assume that Sir Richard knew that when he was writing these emails. He knew that in depriving the appellant of the RMB, he was going to be taking a decision which meant that this person was not going to be getting all of that analysis.
Well, there had been an RMB earlier, right?
Yes.
Yeah.
But one wasn't going to be done before the 2020 decision. So that's one part of why I say not cogent, because the chair knew, I infer, I hope reasonably,
What an RMB was.
what an RMB was and
Indeed.
what the benefit of the RMB is as compared to the something else. Now that requires me to evaluate...
I mean, this is why I'm bemused, really, because something else might easily be an RMB.
But we know it's not.
At a different time.
Of course, but we know it's not. We know it's the bespoke process. So instead of the RMB, I'm going to give you a bespoke process.
But we don't know that. At this point, we don't know that. What he's saying in these emails is governance arrangements will be established. I mean, I don't think it's confidential on a case-by-case basis. You know, that's what bespoke means. So we're setting out a process.
Could I just ask my Lord to look at page 204 just to make sure?
I am on 204.
Just
I'm
the
looking
little
at
bit in
point
green.
one.
Yes, I just wanted to...
I'm looking at point 1 of the email,
Yeah.
and that's what he says is correct.
Yes.
Yes.
So, in fact, my Lord has made one of my points for me, which is it wasn't even articulated what the process was going to be at that stage. So it's even worse, because it's not RMB, but here I have another crafted solution. It's RMB, but I'm going to do it as and when.
You see, this is the trouble with subjecting this kind of decision-making to this kind of very, very close scrutiny. And I'm not saying if you're right about the fact that it has to be subjected to this very, very close scrutiny, then you're right, and we will have to do it not only in this, but in every other case. But the problem with it is that the decision he takes here is not as to what everything that's going to be done in the future.
No.
The decision is that there isn't any point in having an RMB now because he's changed his position and
Yes.
leaving the country, and we don't know how much we'll see of him in the future. But when we do, we'll have to take case-by-case steps.
Yes.
Now, to say that that decision has no good reason, is irrational, or anything, whatever language you want to use, is difficult because it's sort of kicking the ball down the line a bit. And
Well,
saying,
I'm not doing that, my Lord. I'm saying...
No, you're not kicking the ball down the
But
line.
he's-
But maybe this
he is.
decision is only is an interim stage.
But, well, could I analyse it in this way? That there's the what we're not going to do, and there's the what we're going to do. The what we're going to do is unclear, as at this particular time frame. Obviously, we now know what has been done, but as at 24th, 26th, 27th February...
But you're putting, if I may say so, and I don't want to put it too colloquially, but you're putting your money on the absence of an RMB as at February 2020. And what I'm suggesting to you is that this decision is not really making any final decision about when there will be an RMB. It's just saying that the claimant is leaving the country, stepping back from royal duties, and will deal with what happens in the future in the future.
Yes, and there's a response I want to give, which I'm not able to give to that particular question, because it's confidential information.
Well, you've given me two answers, I think, actually, since I know what's in the confidential information. I don't actually...
Well, it's about the things that haven't been done.
Yes. It's about the nature of the RMB, which is you told us, and it's about others. Is that right?
There's another part to it. I'm not trying to be
that you can't even.
That I can't say. I can't say.
Right.
But my lord, I'm not putting all my money on it not being done at this particular point in time, because we are where we are in the point in time, and my lords have evidence, and I will take you to it about what has been done in the interim. Now, can I just
to appeal, but I thought one was that the judge erred in concluding that there was a good reason not to follow the policy of the executive committee, and that the policy was that an RMB should be done before taking a decision. I thought that's what it meant.
I'm so sorry, my lord. Could you just repeat
Your
that?
ground says the judge erred in concluding that there was good reason not to follow the policy, the terms of reference.
Yes.
And I understood you to be saying that what they didn't follow was to commission an RMB.
Yes, that's correct.
Yeah. So that's why I said you had put your money on the decision not to have an RMB in the letter of the 28th of February.
Yes, but what's relevant to considering that is what has been done. So I think my lord gave me the example. They could have done RMB plus plus plus.
Yes.
It's highly unlikely that we would be here if that's what they'd done. The reason we're here, given their failure to do the RMB, is because of what has been done. So it's a comparison between what he is entitled to in our submission and what he's got. That's why the failure matters. That's why they needed to have a good reason. It wouldn't have mattered if what he had gotten was equal to or better than what he was supposed to get. So that's what I mean about it's not just all on the negative, because you can only understand how much of a negative it is when you evaluate it or compare it to what has happened.
I mean, you'll forgive me if I'm wrong about this, but I'm not sure how much it's permissible to place any great reliance on the fact that I'm only questioning a decision made in February 2020 because of what happened in 2023. In a sense, you do have to be able to establish that the decision made in 2020 was wrong under the policy in 2020. Do you
Yes,
know?
absolutely. Absolutely.
I mean, you may say, well, I wouldn't be here in court if other things had happened, and that's a perfectly reasonable thing to say, but it doesn't affect our decision-making as to whether the judge was right or wrong.
Yes.
Right?
Yes.
Anyway, I've tried not to interrupt you. And
I
haven't very much, but you haven't got much time left. Which
No, I've actually made more progress than I had hoped, so I think I'm all right for time. But my lord, can I just say this? I will address the concerns that my lord has expressed.
Yeah, and you'll have overnight to think about it.
Yes, but I'm also restricted, as I hope the court will appreciate, in laying out all my wares today.
Yes. Well, for my part, I've got one or two questions I'd like to ask, but I propose to do that tomorrow.
Thank you, my lord. Can I just find my spot again, please? So I had shown you the evidence, and I just want to show you the judgment on the evidence. 169.
I mean,
It's paragraph 169, and it's page 138.
yes.
And he says that the 24th of February email suggests that there would not be a need for an RMB because there there would be a tripartite mechanism, and you can see the rest of that sentence. Now, the judge says, later you can see in para 170, that contemporaneous evidence is compatible with what's said in the witness statement. And the court has the point that I've made, which is the lack of the explanation in the contemporaneous evidence. And then 174, he again makes a similar point, to which we have a similar response, which is the chain says that there would be a change, but doesn't explain why. And then the significant weight that I referred to earlier, he says in para 174, and you have my submission on that weight and why we say it can't be given that weight. Now, Sir Richard's first witness statement refers, and this is again the distinction between the contemporaneous and the witness statement point, his first witness statement refers solely to the fact that he had in his mind that there may be significant public upset, is the way he puts it, if harm came to the appellant. That's Mottram 1, para 99. His second witness statement says that he had regard to the impact of a successful attack on the appellant. So that's Mottram 2, para 11, supplementary 147. And the judge relied on that evidence in concluding that there was a good reason. So this was part of the evidence he took into account. He had the emails and the evidence about the change, which I've shown you, but then he also took into account this evidence about impact. And this is particularly important because, as I've said to you, the RMB considers impact. And the judge relied on this, you can see, at para 186. You can see there he describes this. The problems with this paragraph and with this reliance on Sir Richard's evidence is Sir Richard does not articulate how impact was considered. And there's no suggestion that it was in the structured way that we'll come on to see is done by the RMB. And there's nothing in the contemporary materials at all about impact. Now, all of that is to say that on one of the major strands that the RMB considers, that is impact, we have the witness evidence of significant public upset and impact of successful attack. We don't have any more. The court doesn't have any more as to how that was done, what was done, and there's obviously no paper trail. Now, again, in terms of, my lord, I see my lord the master of the rolls.
Well,
I can anticipate what's coming, my lord.
It's a 500-page point, isn't it?
No, my lord, it's not. It's really not the 500-page point. It's actually, there is not an explanation for a critically important part of what the RMB does.
Well, the judge says it would be bizarre if they didn't have it in mind.
Of course, it would be bizarre if you didn't have it in mind in a general sense. I'm sure if you stopped anyone on the street and said, you know, if an important public figure was hurt, what would you think the impact would be? Everybody would have a knee-jerk reaction. That's not what the RMB does.
No.
But Ravec itself, I mean, the judge says the impact both at home and abroad of a successful attack on a particular individual lies at the heart of the rationale for Ravec's existence.
Yes.
What else are these people appointed for?
Well, my lord, when you say these people, I would say the RMB and Ravec. That's the point. It's a dual-layered system by design. And so I entirely agree with you if you're reading Ravec as including there the RMB. And that's the whole point. That's why we're here, because we're saying Yes, of course this is what Ravec does when it does it properly. When it gets the RMB to look at all of these things that it has said the RMB should look at after recommendations in a review.
And I think I, anyway, understand. This is a process challenge. The RMB is separate from Ravec. RMB has special expertise and would have addressed the impact on the claimant in a way that it has done for others. And in those circumstances, you say it is unfair and inappropriate and improper not to follow the terms of reference. And that's very clear. And you say it's not any use saying, well, there's other things you could do without a very close analysis of why that is sufficient in comparison to the expert analysis of the RMB.
Especially when one looks at how others have been treated.
Yes, well,
that is
included others, because
yes.
I know that's a large part of it, but we're not going to discuss others in open.
No, but my lords, that explains that this isn't some arid point about, oh well, your process says you've got to go to that body and you didn't, and that was bad. This is about substance, as I've shown you by going to the evaluation criteria, but it's also about let's actually look at how the RMB came out on these cases and what's happened here. And I will be asking the court to look at the individuals. I will be asking the court to do that. That's my ground too.
Yes.
And I will be saying it is irrational.
Yes.
It is irrational. It's a different point, but it's part of this analysis of impact. It is at the heart. It's
1C or 1D. Yeah.
Yes, 1D and ground 2. That when you actually look at how the RMB has evaluated impact and the conclusions that Ravec has come to, taking the RMB report into account, and then you look at what Ravec has done for the appellant and the conclusion that it has come to, something has gone wrong. It does not make sense. That is what I am going to be submitting. And so I don't want to be labouring the point about the RMP and the terms of reference, but one doesn't understand the significance of this until one gets under the bonnet and looks at how things work.
Your answer to my lord is the RMB is qualitatively different.
Precisely.
From Ravec.
Precisely.
Different expertise.
Yes.
And a different outcome.
Yes.
And he's been deprived of that, and
yes.
he should not have been in the circumstances of February 2020.
Yes. And to respond to my lord, I'm not trying to in any way say that Ravec doesn't have expertise. I said that at the outset, but my lords have seen that the Ravec expertise kicks in at the risk evaluation stage, not the risk analysis stage. And that's Ravec's own choice to have done it that way. Two-tier. So Ravec is, of course, considering, and the judge rightly notes, of course,
risk evaluation and risk analysis.
Yes. So
Ravec is risk analysis, RMB is risk evaluation.
The other way around.
Sorry.
So, my lord, that is ground 1B and C, and I'm going to just do grounds 1D. I think the way that we would put it, if I had to put it in a nutshell, is that we would say there's nothing better than an RMB.
Yeah.
And that's why it's used for everyone else. Now, just grounds 1D and 2 in brief, because I can take this quickly. I'm going to deal with ground 2 in the closed session, because so much of it is the comparison with others. But just for my lord's note, that's the judgment at 181 to 192. So just a few words, if I may, on ground 1D. Ground 1D does not appear to have been expressly addressed in the judgment at all. And the court may have seen that in paragraph 250, the judge notes that we made some points after we had received the draft judgment. And this is, if I can ask you to pick it up from 165. you'll see that he says that after circulation of the draft judgment, the claimant invited the court to refer expressly to the following submissions that the claimants had made in the course of the hearing. And then over the page, it's the third point in that paragraph. Third, the claimant says that without an RMB analysis, Ravec could not lawfully reach the conclusion that the claimant should not be treated as within the OVC. And what the judge says in paragraph 251 is essentially to say that there are further examples of the overarching problem with the claimant's case, and then to refer to other parts of his judgment. Those other parts don't appear to address this at all. So you see he refers to paragraph 201. That's not something that deals with this, certainly not expressly. What ground 1D is trying to get at is that when Sir Richard made the decision in February 2020, he didn't have a proper factual basis on which to consider whether or not to treat the appellant akin to the OVC, because he wasn't properly informed. And that's because we say he didn't have the RMB. So he took a decision about how to treat the appellant without thinking about it in the way that the terms of reference require. So you can see that this point builds on the other points, but it's really, again, the point about impact. And if I ask you to have a look at Mr. Hipgrave's witness statement, the first one, paragraph 62, just for your note, I'll go to it tomorrow. We say that in light of the matters set out there, the failure to get the RMB in February 2020 means that Sir Richard wasn't properly informed, especially about impact, and therefore he couldn't make that proper decision about the protective security. So I appreciate these are broad categories, and I'm not trying to suggest at all that, you know, they're formal categories and that Ravec treats them as distinct. But in terms of what you've seen in the emails about how he was approaching this, once that question 2 had arisen, which you saw in his 24th of Feb email about the fact that he wasn't in that role anymore, but we still have this problem, at that stage the answer was, let's get an RMB and then figure out how to potentially categorise him. And I don't mean by that in a bucket of, you know...
No, but you say they needed an RMB before they could categorise him as an AVC or not, and they didn't do that, and they weren't in a position to do it.
Exactly. So it's a very short point, but it's an important gateway point.
The evidence on it will require closed session.
Yes, and that's the ground 2. So it's really the gateway point to ground 2. So, my lords, I'm going to come back and deal in private with the points I've flagged.
Yes.
But those are the submissions.
Thank you very much. Sir James.
I was just briefly, by way of introduction, if I may, the decision under challenge is the one in February 2020, as the Court has noted on a few occasions now. That's in the core bundle at page 367. And it was, in a summary, that the appellant would no longer necessarily be provided with the same degree of publicly funded personal protective security when in Great Britain, following on from his change of status. It's important to emphasise that the decision was not that personal security of the kind previously provided would under no circumstances be provided in the future. Rather, it was simply that that security would not be provided on the same basis as before because of his change of status and because he was now going to live abroad for the majority of his time. But he would be provided with personal security to the extent appropriate in certain circumstances, and those circumstances would need to be considered in the future. That was the nature of the decision. So the decision in overall, but we submit accurate summary, was that he is now in a bespoke position with bespoke arrangements having been made for the consideration in whatever detail Ravec and the other bodies involved consider appropriate in the future. And once that is apparent, it is self-evident, we submit, that we are in territory in which there are no right or wrong answers. There are matters of judgment against necessarily broad and soft-edged criteria, especially predictive assessments of risk and impact and all the rest of it, including matters on which the security expertise of those involved is likely to be critical. The key evidence in relation to the decision-making and the reasoning of Ravec is set out in a long and very carefully detailed section of the judgment between paragraphs 83 and 135, going through, as you've seen, with great care all of the evidence. Particular reliance was placed by the judge, we submit entirely properly, on the two statements made by Sir Richard. You find those, if you want them, in the supplemental bundle. The first one, tab 2, page 34, and the same bundle, tab 7, page 144, is the second one. He was the chair of Ravec from 2009 right the way up till April 2021 and is now retired. And also in the statements of Mr. Hipgrove, again you've got two witness statements from him, or the court below had two witness statements from him. Supplemental bundle, tab 4, page 79 is the first one. Tab 9, page 159 is the second one. And you have their background and their experience, and indeed their expertise, summarised by the judge, particularly at paragraphs 11 and 16 of the judgment. I emphasise one final point by way of introduction. Most of the careful and detailed description and analysis of the judge, the detailed description of the evidence, of the decision-making, of the factors taken into account in considering his personal position, and so on, and indeed the myriad other grounds of challenge, are no longer challenged in this appeal. And therefore the rest of the judgment, as it were, aside from the grounds, the relatively narrow grounds on which permission has been granted, now provide the unchallenged backdrop against which those narrow remaining live issues fall to be considered by this court. It is therefore, for example, uncontroversial in this appeal that the decision did not fail to take into account any material consideration. That was old ground 2. It was dealt with described by the judge in terms of the description of the ground at 137 of the judgment, and was disposed of at 238 to 249 of the judgment.
Well, all you're really saying is they didn't get permission to appeal on the other matters.
My lord, they didn't, and there's been no application to revisit
No,
that.
absolutely, but, you know.
Can I just give you
doesn't mean it's common ground.
I'm not suggesting it is.
Yeah, no.
But it is important for the court to appreciate what is no longer live at this level.
Yes, well, I think we understand it's definitely not live at this level.
Very well. In which case, you will also note that what is not live is that the security arrangements in the decision were not unreasonable. That was a rejection of the rationality ground, 138 of the judgment, and then 238 to 249, where the judge took grounds 2 and 3 together. And there was nothing procedurally unfair about the decision-making. That was ground 4 and ground 5 below, described at 139 to 140, dealt with 213 to 232. So what is left are a collection of subgrounds under misapplication of the policy, no good reason to depart from the policy. And we submit that that ground 1 effectively breaks down into 3 points. First, that the judge, it is said, failed properly to construe and apply the terms of the 2017 TOR and should have held that in every case, in every context, an RMB analysis must be obtained before a decision is taken by Ravec on the provision or not of protective security and needed to be taken here. In brief summary, and I will develop each of these in a moment, but in brief summary, our response to that ground is that it requires an overly rigid reading of the terms of reference, and in any event, it is clear that there can be departure even from the most rigid and anxious, if I can describe it in that way, policy. The second point that is made is that in considering whether Ravec had good reason to depart from the ordinary approach of an RMB assessment, the judge was wrong to show respect to the primary decision maker, to recognise that there was no relevant statutory context here bearing on that question, and to treat that as significant, and to draw on an analogy with the Thameside duty, which, as you're all very well aware, is a duty to make rational inquiry. And our submission in brief response again in relation to that second main way of putting the case is that the judge was right to recognise the relevance of the expertise and indeed the constitutional responsibilities of the relevant decision makers in concluding that there was good reason in this case. And we've got a respondent's notice point, as you know, which it might be thought to be dancing on the head of a pin to some extent, but we raise it anyway, which is a question of law as to how you approach that question.
That point is actually of some importance.
Some broader importance.
It may not be in this case, but it's of great importance.
It is. It's whether or not it's a rationality standard or it's an objective thing for the court, effectively. We're back into that territory, but you'll have seen the significance of that, but that fits under the second point.
Yes.
And of course, if a rationality standard is to be applied, then ground one rather falls away in the light of the findings as to the rationality of Ravec's approach that were made by the judge and that are the subject of a live appeal now. That's the second issue, anyway, or the second two bits of the second issue. The third main point is that the appellant contends that the defendant, Ravec, did not have a good reason to depart from the usual policy of obtaining an RMB assessment.
No good reason, cogently, and other adjectives expression.
Well, there'll be a question about that, but to some extent that takes one back into the expertise issue, because you can produce any number of adjectives or adverbs to describe a concept, but ultimately what may matter is the substantive things that feed into the level and degree of the court's scrutiny. And my lord and I have had that debate on a few occasions in the past, including in relation to controversial policies like Rwanda.
I have a vague recollection of it.
I thought, you're not the only one, my lord. So anyway, that's the third basic thing. And again, in summary response, we submit that the usual position, which we fully accept, as set out in Ravec's terms of reference, was that decisions on the make-up of Ravec's cohort would be informed by an analysis produced by the RMB, but here the decision made by the experts involved, including, I add at this stage, both the chair of Ravec and the chair of the RMB, who was the main second party to the email correspondence you've just seen, was that a different approach was not merely appropriate, but a better one in the circumstances. We will say, secondly, that there was good reason, however judged, by which I mean by reference to whatever standard that is judged, and it lay in the appellant's unique circumstances requiring the sort of bespoke approach that one has seen, for which purpose i.e. for the purpose of those unique circumstances, the RMB assessment was neither appropriate nor especially informative. And as an aspect of that, and finally, the conclusion was that bespoke process was better suited to the appellant's circumstances. So the decision was, in essence, that the appellant would be better served by this approach, not, as the appellant appears to assume without foundation, deprived of some form of useful procedural benefit or advantage. And indeed, it might be thought to be a striking feature of this case that the appellant is complaining that it was unlawful for the decision maker to consider his case directly and specifically, and to go on, by virtue of this decision, or deciding to go on considering his case directly and specifically in the future, rather than simply applying a more broad approach to it. That is, might be thought, rather the reverse of the usual case, which is to argue that there should have been less discretion exercised and not more. I leave ground to that the contention that it was impossible for the defendant to conclude that the appellant should not be treated as falling within the other VIP category for close, for obvious reasons.
You haven't mentioned in your 3 points the point that Ms. Fatima made quite a lot of, even though she's going to give us the detail in closed, which is the comparison with others, and that there isn't a good reason when you compare with others.
Well, yes, I'm going to pick up, to the extent that I'm able to in open, I'm going to pick that up probably tomorrow now.
Yes.
There will be something that can be said in open, but it's very limited for all the reasons that you're well aware of.
But, I mean, obviously that does form a major plank
Of the appeal.
of the appeal.
It certainly does, but there's a particular limit and a greater limit on what can be said in relation to that ground by either of us.
Well, no, that's true, but I think it comes into the paucity of reasoning that was pointed out in the emails, which you are going to have to address.
Yes,
which
well,
you can
well,
address in open.
I'm going to address those emails in open. I'm going to address, to the extent I can, do ground 2. Can I turn to the first argument, and the first of the main points that is raised, which is the interpretation of the 2017 Ravec terms of reference. We've dealt with that in our skeleton at paragraphs 12 and paragraphs 20 through 26. 2 principles of relevance, if I can start with the principles, if I may. The first is that the interpretation of a document, a policy document, a guidance document, whatever it may be, whatever its essential character, is an objective question for the court, as we accept, although the policy, if that's what we're dealing with, is not to be interpreted as if it were a statute or a contract. And we get that proposition, which reflects, I think, a degree of common ground between us, from Mandalia that you've seen at paragraph 31, Authorities Bundle, page 485 to 486, tab 12 if you're in hard copy. I don't know, is any member of the court on hard copy? Otherwise I'll just drop the tab references. I don't know whether Justice Bean is.
I am for authorities, but...
Would it help to have the tab numbers?
In fact, the pagination is wrong because
okay,
the versions have been changed. But
I'll
if you just give pages and paragraphs within the judgment.
Yeah, paragraph 31 of Mandalia, 485 to 486. Suffolk Coastal at paragraph 22, per Lord Carnworth.
You call it Suffolk Coastal.
I call it Suffolk Coastal. Is that a wrong reference?
Isn't it?
Hopkins Holmes.
Yes, Hopkins.
It's Hopkins Holmes. Sorry,
it's the same.
I don't want to cause confusion.
You
it's
are.
The same. Well, I'm sorry. Hopkins Holmes. I'm going to come back to it. It's tab 16 anyway, page 633 to 634.
Yeah.
The second principle is that precisely because a policy is not a statute, but is a document which has been adopted in a specific context and is usually being applied by decision makers familiar with it and the public interests it serves to further, particularly when one is dealing in a context where there is expertise. The Supreme Court has emphasised that the courts should respect the expertise of specialist decision makers, and as it was put in Hopkins Holmes, so we don't have the confusion, paragraph 25, start at least, as Lord Carnworth put it, from the presumption that they will have understood the policy framework correctly.
That is directly challenged in this appeal as being applicable here.
It is.
Yes.
And I'll address that immediately, if I may. The basic challenge that my learned friend mounted this morning was to say you can't extrapolate any form of general principle from that because it was a planning case. It was all about planning, as she put it. And my first riposte to that, is that it wasn't all about planning in the sense that she refers to that phrase. It was all about expertise. You'll recall the passage in Lord Carnworth's judgment, and you probably ought to read paras 22 through to the end of 24 as a piece, because he cites from earlier judgments of Lord Reid about the Raisi principle, it being an objective matter for the court in ordinary cases, and then goes into the expertise bit in paragraph 24, which is the critical one, 24 and 25, which is the critical one for our purposes. But my first response to my learned friend is that statement of principle, start at least from the presumption they will have understood the policy framework correctly, is particularly linked and attached by Lord Carnworth as a principle to expertise. So it isn't some sort of strange planning principle.
No, but what Ms. Fatima submitted was that this is different because it's not some kind of guidance, policy by way of guidance. It's a policy by way of a clear process from which you are not intended to depart because it's telling you what to do. And you don't therefore depart from it just because you say, I'm an expert, I'm going to depart from it.
Well, no one says you do that. You can't turn up and say, I'm an expert, so you don't need to bother with any of this.
No, that's what she is submitting, is the reason why deference is inappropriate here. It's not just because it's planning, although that's the context of that case, but it's because this is a policy which tells you what to do.
Just as the planning policy documents told the planning people what to do.
Well, planning as we know, we've all done planning cases, Sir James, and they are slightly different, but you say anyway that it is a principle that is applicable across the piece.
I said,
and you are departing from guidance in a policy, even if it is
telling you what to do.
Unequivocal. Yes.
Yeah, I do say that, but I don't need to go that far. And if by across the piece you mean in every situation in which policy is promulgated by anyone, I don't need to go that far, because the principle that, as expressed by Lord Carnworth for the Supreme Court, was tethered not to planning and the weirdnesses of planning, which we all know about, but to expertise. So there's a particular reason.
Well, I mean, can I just put this to you? The other cases in the immigration context, it isn't right to say that expertise is unique to a situation like this in security matters or planning matters.
No.
Even in immigration matters, where you have some very clear policies for decision makers to follow, the decision makers do nothing else but make these decisions on the basis of these policies. And what I think Ms. Fatima submits is it's a distinction without a difference in this situation.
But that would apply equally to undercut the application of it to planning, because you could say that about planning. My submission is that in relation to immigration, to take that example head on, it will depend on what the policy is and who's doing what with it.
What she says is that there it is quite clear that despite the expertise of the people making the decision, you don't pay deference to their expertise. You look to see whether they have followed the the effectively mandatory guidance, and then if not, you look for a properly, cogently explained good reason.
Yeah.
And that, of course, of course, you bear in mind that the decision has been taken by an expert, but that's not the beginning and the end of the matter.
Well, none of the reasoning in those immigration cases puts it the way my Lord has put it. You take into account their expertise and then you discard it. And that is no doubt because the policies that they were considering in those cases were policies that applied to a large run of cases going through the system and decision-making by officials at all levels, including the most junior, in relation to the run of cases. That's why I say it all depends on the policy and what you're doing with it, because there may be different bits where you are, I don't know, for example, designing a particular specialist part of the system where the argument might play in the context of immigration. But again, one doesn't need to solve all the ills of the world in one go. The fact of the matter is that here we have a paradigm example of a short, crisply expressed set of terms of reference being operated by people who are appointed for the specific reason that they are expert in this field. And my submission is that that is a fortiori the sort of context that led to the principle in the planning context that Lord Carnwath was talking about. It is directly about particular expertise in a particular context requiring it. And so I don't really care whether in certain parts of the immigration world you might be able to say that some people are expert in it because they do it day in, day out, but it's a very different circumstance, and the circumstance in which they are expert is non-comparable. But if you take the base principle as one which is tethered to expertise, and that's how it's expressed.
I just wanted to be sure that you were going to meet the point that is put against you. That's the reason.
Well, my Lord, that's my answer. My answer is it's a principle that is tethered to expertise. Here we have an absolutely paradigmatic case of expertise, and that renders the application of the principle described by Lord Carnwath in the planning context as being a fortiori applicable. And it certainly cannot be dismissed on the basis that it was all about planning.
Well, I mean, I'm not going to you're going to take us to the cases that you think are relevant, but it was pointed out in argument that the Hopkins principle was not referred to in later cases where they came back to the good reason approach.
In the immigration sphere. But the only case in which, to which that was, in relation to which that point was made, or the principal one, was the Hamati case, which you'll recall.
I do.
And the Hamati case was again a very different context. It was about detention in the immigration sphere. It was a broadly expressed policy that cut across all forms of detention in that immigration context. So not a context that attracted that sort of expertise analysis. And the issue there, the principal issue there, was whether or not the policy was to be treated as being law, in inverted commas, for the purpose of EU law. As you'll recall, you see that from the context in the head note, which you will remember. And so the significance of Hamati is not to undermine in any way the statement of principle from Hopkins Holmes at paragraph 25, also unanimous Supreme Court, with its tethering to expertise. The explanation for the non-reference to that case is either the total incompetence of counsel representing the government in that case, or because the Supreme Court, and indeed counsel representing the government, did not regard that principle as being relevant in that particular context. So we respectfully submit that the absence of reference to Hopkins Holmes in Hamati cannot possibly be equated, which seemed to be the suggestion, with the idea that the Supreme Court were in some way, shape or form restricting the application of the principles set out by Lord Carnwath in paragraph 25 solely to the planning context. There is no suggestion whatever that the Supreme Court thought it appropriate to row back from that principle or to disagree with it. So that's what we say by way of principled answer to the way in which this is sought to be attacked by my learned friend, and the case law on which she relies. It's perhaps also worth picking up on the basis that one's considering what government policy is for this purpose, and I'll come back to this point by reference to the Good Lord project, which, my Lord, I know the Master of the Rolls will recall. But it is at least worth remembering that in at least one of these cases, the Supreme Court in the Friends of the Earth case did address and did consider what, when described in legislation, the concept was government policy. That was a legislative term that they were considering, and they considered what that meant. And it is perhaps worth reminding you of that when considering this matter, if only to flag it. If you go, it's not in the bundle, but if you go to Friends of the Earth isn't in the bundle, but if you go to the judgment at paragraph 152, and the second paragraph, the second half of 152 on page 131, do you see a reference to Friends of the Earth, Supreme Court Friends of the Earth in 152, halfway, about 7 lines down, page 131? Can I invite you to read from there to the end of the paragraph? So there they're calling for something which is so clear and unequivocal because they're tying it to the reference to legitimate expectation. Again, to some extent, it's a throwback to the basis of principle from Nadaraja, but you see an application of it in Friends of the Earth there. And of course, if it's tied back to legitimate expectation, in order for anything to get off the ground in the context of legitimate expectation, you have to have a promise of a certain nature, as you're very well aware. Lord Bingham and MFK, clarity and unequivocality being the moniker or the yardsticks of that sort of thing that would qualify as a policy. And there in Heathrow, they were saying, Friends of the Earth, they were saying in order to get within the statutory concept of a government policy, you have to have a policy of that kind. And there was a dispute about oral statements or ministerial statements and whether they amounted to policies. Very different context, but it's that link back to the idea that you don't fall within the rubric, as it were, unless you've got that degree of clarity. So we submit that those are the principles of interpretation. No one is abandoning or inviting you to abandon the role of the court in interpreting these sorts of documents. I've accepted that as my first proposition. It is the role of the court. But the question, as ever, is how, in principle, does the court go about doing that? And there you have all of the notes of caution that I've indicated, including not treating it like a statute, including starting from the presumption when you're in an expert context that they've understood the policy framework.
But that's not a presumption that applies of any relevance in considering what the meaning of the document is. It doesn't matter whether they understood it or not. You first of all have to work out what the meaning of the document is, and then it'll answer itself whether they understood it correctly. I mean, you may take into account what they say, I suppose, unusually for an interpretation exercise. You may take into account what they say they thought it meant, but it wouldn't be the first thing you'd do.
No, how they acted on it. But I mean, that's partly why I said when you go back to Hopkins Holmes, you need to read the 2 or 3 paragraphs preceding paragraph 25, because those do make it clear that the approach in para 25 is an approach that is relevant and treated as being relevant to the exercise of interpretation. Now, of course, it doesn't solve it because the court's still got to do it.
Yeah, I mean, if it were a contractual exercise, you would not be permitted to consider evidence.
Or an exercise of construing a statute. You can't turn up and say, I intended it to mean this.
Well, with a statute, you might have a pepper and heart, but with a contract, you wouldn't have pepper and heart.
Or perhaps it's somewhere.
This is more similar to a contract because this is interpreting. The reason we use the word interpreting rather than construing is because it is not a statute.
Well, my lord, quite. But these are principles that have been developed in the very context for the purpose of trying to assist the court in how it goes about the approach of doing that. Because this is a strange hybrid business. You're dealing in part with.
Do you accept that on a plain reading of the document, although it actually doesn't say it, that there is an apprehension that an RMB will be procured in the decision-making they were thinking about in the terms of reference?
In the usual case, yes. It's describing the key tasks.
In the situation they were thinking about, which is what no doubt Ravec does every day, they would normally get an RMB.
Yeah.
Well, that takes that sort of clears away a lot of the undergrowth here, doesn't it?
It does. And I'm not going to quibble with that, the usual approach. The question is whether it's, as it were, an absolute obligation.
You say there's nothing in
all cases.
the document that refers to a situation of the kind they were dealing with here, so the thing was more open.
That's what it'll come to. Can I come to the application of those principles? One can debate them uphill and down dale, but that's what we say in answer to my old friend's point on Hopkins Holmes. So I don't want it to be taken as an overstatement of our position. We're not saying it applies across the board. We're saying it applies that framework point only in the context of particular expertise, and that isn't restricted to planning. So the application here, the 2017 terms of reference, you have them in the supplemental bundle at page 168, tab 11. They're summarised in the judgment at paragraph 71, and the relevant bits from paragraphs 20 and 21 are set out verbatim, quoted by the judge in paragraph 79 of the judgment. You'll have seen them there. The role of Ravec and the chair in particular is described, as you've seen, paragraphs 1 to 5 of the terms of reference. And C for the chair, and his role, paragraph 72 of the judgment. And the appellant does here rely on what we say is an unduly strict reading of the words at paragraph 20 of the TOR, outlining Ravec's key tasks. The executive committee will, and then coupled with the third bullet is her case. The judge found that here, as elsewhere, the appellant's case had adopted and proceeds from an inappropriately formalistic interpretation of the Ravec process as if it was a statute, which approach was, as the judge put it in paragraph 201, entirely inapt for the sort of decision-making with which we are here concerned. See also paragraph 178 on the same theme. And the judge concluded at 162 that the words could not be taken, as it were, as imposing an obligation in all cases and shouldn't be treated as if they were to be applied dogmatically. And we submit that he was entitled and correct so to find. The basic nature and context are critical, we submit. My learned friend's submissions on the policy documents, including this one, seeks to portray them as having some sort of binding nature, as setting out some sort of mandatory set of rules to be applied by rote, when there are no such thing, we submit. And given the nature of some of the submissions that have been made, it is perhaps important to remind the court of the point made by the Supreme Court in the A case, when it came to review how policies worked and how they should be approached by the courts when challenges were sought to be built upon them. You'll remember the case in question where the judgment was given by Lord Sales and Lord Burnett together for the court. And they said as you will recall, this is page 905 to 906, policies are different from law. They do not create legal rights as such. That was a passage that was quoted, as my lord will recall, at paragraph 56 of the 2023 Good Law Project case. Paragraph 56 is at page 994, and the Court of Appeal in that case, again as my Lord the Master of the Rolls will recall, went on to emphasise in that paragraph why that statement, in constitutional terms, why that statement by the Supreme Court was so. So a set of important constitutional reasons identified by the Court of Appeal in Good Law Project 2023, para 56. And that's why I say the nature of the context and of the exercise is key. Not all guidance or policies are the same, as was made abundantly clear. That was the central nature of the issue, as my Lord will recall, in the Good Law Project case. There are different types of policy. Everything depends on context. Everything depends on the specific facts. And it's no good, it might be thought to be something of a flaw in my learned friend's approach to the principles that she set out at the very beginning of her submissions, which is you can't simply take a bunch of principles from a whole variety of different contexts and then present them as though they were absolute or general. Almost everything in public law is critically dependent upon context, and our context is no exception. We make 5 submissions on the basic nature and context.
Is now a good time to start with 5 submissions?
My Lord, I can break if that would be convenient. We're going to run up at a hard time difficulty at some point in this case, I suspect.
Well, you can make 1 or 2 of them.
No, I don't want to trouble you if it's been a long day.
If there are 5 submissions you're going to read out, I'll tell you what you can do is you can send them electronically overnight, and then you can get them through much more quickly in the morning.
Yeah.
And I still urge Miss Fatima to get her team to send her principles in writing, but electronically, please. Okay, well, we will break there. We will have a bit of a time issue, Sir James, so we'll try not to interrupt you as we tried, perhaps unsuccessfully, but mostly successfully, not to interrupt Miss Fatima tomorrow. And I would urge you to be as economical as you can, so that nobody feels hard done by the time precious. Very good. 10:30 in the morning.
I think the Jewels were in it.
By the way,
It was,
I'm on the live just testing it out. So
it wasn't on. It wasn't on. When you looked on the DJI app, it didn't come up.
the day before it was.
But on the day, it didn't come up.
what was that?
The exclusions.
Oh yeah, it was forbidden. Yeah.
The plane flew into it, and it says it stopped it, and it says you have now lost control of your drone. You'll be returned home. You've driven into it flew it. It was the floodlights on the side one when I got to that. Because you said, and that's the clearest picture. And after that, it went grey. The screen went grey. And it just jumped back on.
It was a shame. I mean, it's
So
just the sky.
mainly think of you.
That's what
So
it was.
I thought I just cancelled mine.
You understand it.
I put it in the week before. It was absolutely fine. And then during the week, the exclusions of.
You can understand it for safety reasons.
Oh, I mean, you don't want to be flying over clouds, and do you? You know. If anything knocks out of the sky, it hits me.
Fix some granny out.
Exactly. Tom, Steve, yes, it's been a while, hasn't it? Yeah.
Do you want me to stand behind your camera?
Yeah, it's on a bit of rush, I was on the nice bird.
Or are you? I'm going to do this. Well, I'll just stand where you are because I need iPhone. I'll just need that with you. Just the clutch it or not.
Is that how your mic going to go any higher or not?
It can do, but it doesn't have to. Well, do you want to clip it to it?
Just clip it to it, right? Somehow.
Is he going to be standing on here, do you think?
Yeah. Well, ask him to stand there.
Ask him to stand there?
Yeah.
Yeah.
We'll orchestrate
Okay, how many stripes you got?
Stand there, sir. Look nice, just nicely backlit there. You know what's happening? 90 seconds. That'll be it.
Do you want another stand?
Wouldn't mind. I've left mine in the office when I come out.
Yeah, just 1 second.
Cheers,
Just, fill them up.
What happens when you come off sitting on the desk all day and you come flying out? You've left your bits.
Can I hear what you guys do?
You can, indeed.
Live, put a line.
You know, there was a shoot.
Oh. About action as well.
I've got the DSLR, but I still prefer this. I do it for the run. I've got the FX3. That's great. For those sort of moves and whatever, but the normals. It's what I know, you know. It's a good old zoom lens and everything.
See, I live in a terrace house, so I've got a beach at the bottom of the street light. But still.
Yeah, it's alright. Which beach?
Whitley?
Oh, you Whitley?
It's nice. I prefer Whitley. The time off me, time off is good business. Actually, put it back. What's your daughter doing?
She works. She's a friend. She's for Young man, can I get you to stand in on the second step?
Yes. Be the second time now.
Yeah, I think that. You're going to make a line, are you?
Yeah.
We can start now.
Or would you prefer him on the first step?
I'll put them on the first step.
Can I try you on the first step? If that's all right.
It's probably better with the time. Yeah, second.
Hello.
Second step.
Second step.
Second step. Yeah, second step, mate. Yeah.
I knew you'd be here, that's why I rushed. I'll do it.
I'll just hang out, Sandy. I was just at the betting shop, you know.
Hello.
The betting shop.
Sure, just so I can get
Here a little bit so you can get the police sign in behind, because
well, I'm just going for the door.
Steve, level for you. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. 1, 2, 3, 4. 1, 2, 3, 4. The gate's this. Okay, bit of level everybody. 1, 2, 3, 4. 1, 2, 3, 4. How's that sounding? All right.
Yeah, a bit more key.
1, 2, 3, 4. 1, 2, 3, 4.
Yeah.
All right.
it's yours. It's yours, all right. Is it?
Auto.
No, mate, no.
All right.
Mine's on here for always all right.
Yeah.
Then I set this. Then I set this on here.
It's very, very close. You're coming to standing with about 5 or 2. It's just before them.
I did that again.
See, you got all these all focus this time. I was still going to in the heart.
No, I just pressed that back button.
Yeah, it's all
All back button.
Just do what you got to do, don't you? Something's up.
I didn't realise that how to work stuff from the people. Jenny Blackhead was the national people. Oh, straight forward. Yeah, Fiona Trottle. She had to do a lecture in the German students in the union. But I had it before, right? And so all these parts. Anyway, so they're all there. Anyway, he's I had to go and relate, all these fucking kids were asking all these technical questions now. And said, what was at the end of the lecture? They said, what advice did you give? Right? And they were expecting to come out with FE and all. I said, no matter how good you are, right, is you take a shit like this while you leave the house in the morning and walk over. Because doesn't matter how good you are, if you haven't actually clean your shit like this, you're going to miss it. And if you haven't got a pack of coat on, you're going to freeze it.
Yeah.
And you're going to be miserable. Right? She goes, she's on the top of it, she's upstairs. Put the toilet for you, you've warm shoes and a warm coat.
Good advice, huh?
It doesn't matter how good you are, if you're cold, you're miserable.
I mean, I don't know what they were talking about live.
Pictures that exist pretty much at all. I was just thinking that as well.
I don't know, did you do live at the scene last night?
No, maybe it did. Surely it is.
As well, they said, what keeps you motivated every day? They said, taking mortgage will go
Of an ideal world.
What would be your thoughts on doing it around now next year?
Yeah.
Yeah. The recording's still, I suppose the argument against the record's still there, there's still loads of police there. But it's kind of awkward to do it on the main drag. It's vandalism, not academics.
Contained here, and we've got the shots in there anyway that can go over the top.
Yeah.
And also,
Do you know what?
The internals are a bit like
What it is?
It all works.
You've still got your mojo happiness. By the time I'm 50, I'll be awake.
I'm sort of.
That's all we need to do. That's all we need to do. We're doing our mortgage office. And
Well, I wanted to do that, I'd say special.
Yeah.
Because, you know, you want to just put your good bit.
They got gas, electric, water, council tax.
Yeah, if you stick with your motors, back to 208,000 miles, hey, yeah.
Still drunk.
Got it.
Sorry. So I wouldn't be using the side tills now.
Testing 1, 2, 3. Like that.
Don't stand the
Just
yeah.
Both your kids can't use it, going to clean me up. That's what's going to make me.
It's just happening with
Yes,
food.
so we're here in Stanley today to do an update for the.
And it's expensive. Just everything. Toothpaste, toilet roll, just everything.
Hello.
Thank you for coming out at like such short notice.
Oh, short, wasn't it?
I know, for those who don't know me, I'm Hannah, I work in the press office. Danny Walker, who's been looking after this sort of incident for us, she's just in there now at the moment with, I think the insight did say DCI car at the moment.